Good morning, everyone. Thank you for joining us for the Medical Board of California's quarterly board meeting, day 2. While this meeting is being conducted with participating board members and staff at the meeting location, this meeting is being streamed interactively using WebEx to allow for remote public comment in the same manner as recent meetings. Public comments for those who wish to speak will be heard for each agenda item from individuals attending in person and remotely. To be ready for remote public comment, we ask that you please ensure your comments can be heard clearly by being connected to the audio of this meeting through the proper method. If you are having difficulty hearing the audio of this meeting, it could be because the device you are connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application and then select Switch Audio. You will see an option to call in and will be provided with a telephone number, access code, and an attendee ID that can be used to connect the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will allow you to still participate and hear the audio of the board meeting. Please see the View Additional Meeting Information link on the first page of the meeting agenda for more information on connecting to the meeting and accessing meeting materials. Thank you, President Lawson. You can now start the meeting.
Thank you, Sean, and good morning, everyone, and welcome back for day 2 of the Quarterly Medical Board of California meeting. I'd like to ask us all to just please turn any of your devices to silent. For members of the public, you may notice that board members are accessing their laptops, phones, and other devices during the meeting. They are using these devices to access board meeting materials that are in electronic format. If you are a member of the media and you require assistance or information, please see Aaron Bone over to my right. Aaron, please identify yourself. This is an official business meeting of the Medical Board of California, and disruptions of the board's business will not be tolerated. Government Code Section 11126.5 allows the board to remove people who willfully interrupt a meeting and to clear the room if order cannot be restored by removing or muting the disruptive people. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand or come forward and you will be recognized. As Sean mentioned, this meeting is also being streamed live via WebEx. Individuals attending the meeting remotely via WebEx will have an opportunity to provide public comment and will be assisted by the host who will be facilitating the WebEx meeting. During each agenda item, the host moderating this WebEx event will activate the hand raising and the Q&A features of WebEx and will ask anyone wishing to make a public comment to indicate so by raising their hand or entering yes in the Q&A window. The host will then call on individuals who indicated they wish to make public comments by the name provided by the individual, which may be a pseudonym. When called upon, the host will unmute the microphone of the individual and they will have 3 minutes to make their public comment, but this time period may be reduced depending on the number of people who wish to speak so that more people may be heard. The host will audibly announce when 30 seconds remain to conclude the public comment, and after the individual's time for public comment has lapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. I'd like to remind all speakers to please stay on topic and keep your comments to 3 minutes or less. Today's meeting will be run according to the Open Meeting Act as required by law, and we do plan to end today's meeting by at least 3 p.m. I would like to now officially call the meeting to order at 9:05 a.m. Ms. Struther, would you please call roll?
Dr. Ayala Rodriguez, Mr. Arkatov,
Here.
Ms. Chung,
I'm here.
Dr. Mahmood,
Yes.
Ms. Rimke,
Here.
Dr. Thorpe, Dr. Tolbert,
Here.
Ms. Torres,
Here.
Dr. Sy,
Here.
Mr. Watkins, Dr. Yip,
Yeah.
Ms. Lawson.
Here. Thank you, everyone. A quorum is present. I would like to remind the members again that we will take a roll call vote on any action item. And we are now going to move on to agenda item 10, which is a presentation on the board's enforcement process. Welcome, Ms. Smith.
Good morning. My pleasure to provide an enforcement program overview this morning, covering all of the areas of the enforcement process. Oops. Okay, sorry. Good. Okay. So as you can see, the statute provides the priority of the board, which is the protection of the public shall be paramount. And the board takes this very seriously in our enforcement process. So the enforcement program is responsible for, Sean, can you go to the next slide? Sorry. The enforcement of the Medical Practice Act, protection of the public, and in instances where we are trying to rehabilitate the licensees through the disciplinary process. And the statute 2229 calls for action to rehabilitate the licensee, but again, when rehabilitation and protection of the public are inconsistent, or protection are inconsistent, protection of the public shall be paramount. And how we do this is we receive complaints from consumers. That's where the enforcement process begins. And we conduct the investigation. And if we meet the burden of proof necessary for the clear and convincing evidence, then we impose discipline. And once discipline is imposed, if it results in a probationary period, then we are responsible for monitoring that. The Central Complaint Unit, CCU, is where complaints are received. We triage the complaints in the Central Complaint Unit. So we are looking to see, are these complaints within the board's jurisdiction? It is not uncommon to receive complaints against other licensees or licensees of other DCA boards or bureaus, such as osteopathic physicians, registered nurses, et cetera. And also, we may receive complaints that involve something that falls under another California agency, such as the managed healthcare. So we're looking at that and we're trying to triage those complaints. Excuse me. I'm sorry, Sean, can you switch to the next slide? Thank you. We're also looking at, does this warrant immediate referral for investigation? And some of those instances that would come into play is if there's allegations of impairment, whether that's physical or mental or due to drugs or alcohol. That's very serious, and we want to get that to the Health Quality Investigation Unit as soon as possible. So in the Central Complaint Unit, we're also looking at those complaints that don't get closed because they are not within our jurisdiction or that are not requiring immediate referral to Health Quality Investigation Unit. We're looking at what are the allegations? What information do we know? What do we need, if anything? Most often in the Central Complaint Unit, when complaints are submitted, they are missing the authorization for release of information, or they're limited to just a day when the care and treatment may have occurred over a period of time. So we'll look at the information, we'll determine what information is necessary. Do we need to request a release? Do we need to get clarification on what the allegations of that complaint are? And so we're in communication with the complainant to request that information. And we are not able to contact a physician to request a response to a complaint without that authorization. And also we cannot obtain medical records without that authorization. So it's vital to get that to be able to thoroughly review the allegations that are brought to our attention. So part of the complaint review process, once the information is gathered for quality of care complaints, they require a medical consultant review. So that entails having a physician who's contracted with the board and licensed in the same specialty as the subject physician of the complaint to review that, to determine and make an opinion if the doctor met the standard of care or not. And in cases when it's determined that there are not a departure of standard of care, that is where the complaint is then referred to the complainant liaison unit when it's a quality of care. I will talk a little bit more about the complainant liaison unit in a moment. Some other options for the complaint process is we might find that there's a technical violation. Maybe the doctor did not maintain adequate and accurate records. So we might refer that for a citation and fine, which is not discipline, it's an administrative action. Okay. Sorry, Sean, can you advance that? It's not. Thank you. So the Complainant Liaison Unit, CLU, is a unit that was created through statute or through legislation, And it was effective January of this year. And it mandates that complaints that are submitted to the board that allege quality of care before closure must be referred to the complainant liaison unit. There are some exceptions, such as a complaint that's submitted anonymously, and some other exceptions. But as I discussed yesterday in my enforcement summary, many of those cases are referred to the complainant liaison unit. So staff in the complainant liaison unit will then contact the consumer to schedule an interview. And this is very important because at this point, we've evaluated the complaint, we've had the consultant review the care and treatment, and it appears there is not a departure for us to proceed further. However, in conducting this interview with the consumer, the complainant, that may offer up more information that we otherwise did not know. So that would afford them the opportunity to provide that. And so if that is provided, if additional information is learned, further review will be conducted. Thank you. Okay, thank you. So in the instance where additional information or new information is learned, the complainant liaison unit will refer that back to the central complaint unit for them to gather that information that's needed. And then once that's obtained, refer that again for a consultant review, because now we have a more thorough picture, because we didn't know before it was referred from the central complaint unit to the complainant liaison unit. We were basing it off what we knew at that time. Through the interview, we may have learned more information. So now we need to have that reviewed to determine the next steps. Now that could still result in closure if after the review, there's no evidence of a violation. It also might result in the referral to the health quality investigation unit for further investigation. Also, the complainant liaison unit took over tasks that the central complaint unit staff used to do, which is responding to inquiries from the public about the enforcement process or providing them status updates on complaint processing. You know, if a complaint was referred to the health quality investigation unit, they can let them know and provide them that information if they maybe lost the letter that informed them of that. Oh, sorry, next slide, John. So this screenshot here is from the board's 24-25 annual report on page 14. It's a snapshot of all of the complaints. So it's not by what the allegations were. It's all of the complaints that were received, and it's broken down into various categories. And so unactionable complaints, that includes complaints that are not within the board's jurisdiction. So as I mentioned previously, that could be against another licensee of another DCA board or bureau or agent, or a concern of an agency that's has jurisdiction over the matter that's brought to our attention. We also receive redundant complaints, particularly with the online complaint system. It's not uncommon for consumers to go on and submit a complaint, and then maybe they have additional information, and instead of reaching out to us to provide it, they file another complaint. There are also complaints that are considered inadequate evidence. These are complaints that are submitted anonymously, and they have no patient or patient representative identifying information. So there's really nothing we can do because we have no one to contact to obtain anything further to determine, you know, what we can do, or if there is a violation, or conduct our investigation. We do receive a lot of complaints where we contact the consumers to ask for those authorizations, and they do not respond. I spoke yesterday in the enforcement summary that we did refer complaints to quality care complaints that are within the board's jurisdiction to the complainant liaison unit to make another attempt to contact those complainants to try to get the information we need to review. Also, if the complaint is quality of care and it alleges patient death, we do have a statute that allows us to proceed after we've made our attempts and have been unsuccessful in obtaining those releases, to then contact the physician or facility to obtain those records, which is huge. Complaints closed no violation are those that the board did not meet the burden of proof to establish that there was a violation of the Medical Practice Act. And complaints that are closed insufficient evidence include those that maybe only found one simple departure, which would not be sufficient enough to proceed with further investigation or action. We also have the other category. This includes maybe complaints that the consumer wanted to withdraw. In instances where a physician is deceased, things of that nature. Next slide, Sean. I will now move into the investigations. Go ahead to the next slide. So as part of the enforcement program, there are two avenues for investigation. We have our complaint investigation office, which is our in-house non-sworn investigators. And then we have the health quality investigation unit, which is our sworn investigators, and there's various offices throughout the state of California. In any case, whichever route the complaint goes, the investigation requires us to gather evidence to, contact witnesses, obtain their testimony, see if we have all the records necessary, and if not, gather more records and information, and conduct a subject interview. Some of the hiccups in both the complaint investigation office and HQIU is obtaining records. And so there are roadblocks that sometimes require us to issue subpoenas for those records. Some possible closures for these investigations would also be closure of the complaints, refer to the Attorney General's office for the filing or consideration of the filing of an accusation, or referral to the cite and fine program for issuance of a citation and fine. Next slide. A large part of the board's enforcement process is the expert reviewer program. Expert reviewers are essential to the enforcement process and can make or break our cases. So the expert reviewer program, they review complaints that are referred for investigation, whether that's through the complaint investigation office or the HQIU. They look at all of the information that's been gathered to that point. So, the initial complaint, anything gathered during the investigation, interviews of subjects or witnesses, and the experts then review all of the information to render their opinion to determine if there is a violation for the board to pursue further action, such as referring to the Attorney General's office for the filing of an accusation. Currently, there are approximately 860 active experts in various specialties. We're always looking to recruit and get new experts. It's vital to our program that we have a large volume and available expert reviewers. Next slide. So some considerations when our expert reviewers are looking at the complaint, and they're looking at determining whether we have a simple or an extreme departure and any mitigating factors. Does the board meet the burden of proof, which is clear and convincing evidence? So gross negligence is defined as an extreme departure from the standard of care, and it constitutes a violation of the Medical Practice Act. A negligent act, which is defined as a simple departure from the standard of practice, we have to have two simple departures to meet the burden of proof. A single negligent act or a simple departure is not sufficient to forward or consider disciplinary action. And as the slide shows, the board has clear and convincing evidence, which is different than the civil, which is preponderance, and criminal, which is beyond a reasonable doubt. Next slide. You can go ahead to the next slide, Sean. So the Medical Practice Act provides the types of violations and allegations. As you can see, I've mentioned gross negligence. And there's also concerns about incompetence. Does the physician lack the knowledge, or, did they go beyond the scope of their practice in whatever treatment they provided? Next slide, Sean. We also have allegations and violations of sexual misconduct, under or over prescribing, and aiding and abetting the unlicensed practice of medicine or corporate practice of medicine, which is corporations and other artificial legal entities shall have no professional rights, privileges, or powers. So sometimes doctors find themselves in a pickle because they lend their license to a med spa, as an example. And they aren't in control of the hiring and the training of the healthcare providers, and they give a layperson more control than they should have. Next slide. So possible outcomes for the complaints after investigation would be, if we don't meet the burden of proof, then we will close the case. We might refer for issuance of a citation and fine. So in some instances, the board may receive a quality of care complaint, and we do not establish a violation of gross negligence or repeated negligent acts. However, there was a medical record keeping medical record keeping issue, or maybe they did not obtain informed consent. So that would be referred to the board citation and fine program for the issuance of a citation and fine. We may also issue a public letter of reprimand. So this is a form of discipline. It may include a requirement for specific training or education. It may be issued for minor violations of laws in lieu of the filing of an accusation. And the board may refer for disciplinary action. They may refer to the Office of Attorney General through the Office of Attorney General, or excuse me, Health Quality Enforcement section. They will assign a Deputy Attorney General to the case. They will review the information, determine, do we meet the burden of proof? And if so, they will draft an accusation for the board to file against the licensee. There are some instances where there is immediate action needed, such as a Penal Code 23 restriction. So this usually is when there's a criminal matter or criminal arrest that's come to light, and the board will, Health Quality Enforcement will have a DAG, a Deputy Attorney General, go to the court when the court case is heard. The criminal case is heard. Criminal conviction is heard, and we might obtain a restriction, partial or full, to maybe limit their practice or totally restrict the physician from practicing. We also might ask that the AG's office seek an interim suspension order. And again, this could be full or partial, if there's a concern about prescribing of certain schedules of controlled substances, they might limit that, or they might do a full restriction. And also, it definitely is necessary in issues or when we identify concerns of impairment that puts the public at risk. All right, next slide. So the collaborative process is something that executive staff, Health Quality Investigation Unit, and Health Quality Enforcement have been working on, and we implemented this November. It is really exciting for all of us. We're all looking forward to this. So this came about through Senate Bill 806, which required the Department of Consumer Affairs to appoint an independent enforcement monitor to evaluate the board's enforcement activities. And through this enforcement monitor report that was issued last March, it identified that the collaboration between HQIU and HQE was necessary. So we've identified the case categories in this collaborative process, the roles and responsibilities. Training has been provided to all parties and involved in this. And we're just really excited to start this process, and the slide represents the goals of this collaborative process. Next slide. I mentioned the citation and fine program. The board has a statute to establish a system of by regulation for issuance of a citation. And so again, these are for violations, but this is not discipline. This is administrative action. We may issue a fine, or excuse me, a citation with a fine or without a fine. So in some instances where we would not issue a citation with a fine might be if we issued a citation for a doctor for failing to update their address of record within the mandated time frame. So long as they met that, they corrected that, we would not have a fine associated with that. And fines may range from $0 to $5,000. And so through the citation and fine program, the licensee or the individual issued the citation does have an appeal process. They may accept it, and if there's a fine, they may just pay the fine, and then the citation is resolved. They may request an informal conference, which is conducted with the individual or their counsel. And it's, just trying to get some more information to establish if we're going to affirm the citation or not. So if the board does affirm the citation, the individual may also determine or request as part of the appeal process that if the citation is affirmed, that they have an administrative hearing. So it could continue on after that, or they might just request from the get-go when the citation is issued that they have an administrative hearing. Next slide. Discipline Coordination Unit is responsible for the processing of the information. They're the liaison between the Attorney General's office. Next slide, Sean. So the board prepares and sends the cases to the Attorney General's office. The DAG, the Deputy Attorney General, prepares the documents, and then the Discipline Coordination DCU staff are responsible for processing that and keeping that moving along. So in the instance where an accusation is filed, the licensee has 15 days to file a notice of defense. If a statement of issues is issued, so this is more for your applicants for licensure, they have 60 days to file an appeal, which is considered similar to their notice of defense. Right. All of these filings, these documents that are listed on this slide are public documents, and they are posted to the board's website once they are filed. Next slide, Sean. In instances where we are aware or informed of concerns for ability to safely practice due to mental or physical or drug or alcohol impairment, the board may petition to compel the licensee undergo an 820 exam. And this is, they can voluntarily do this. We do try to have them assist us with that, but if they do not, then we will have to proceed with filing a petition to compel. And so we do have expert reviewers in the expert reviewer program who do conduct these mental or physical evaluations for the board and then report back to the board what their opinion is on the licensee's ability to safely practice or not. If the licensee is found unsafe to practice, the board has authority to revoke, suspend, or place the licensee on probation or other action deemed appropriate based on the disciplinary guidelines. If through the evaluation they are found safe to practice and there are no other concerns, then the complaint may be closed. Next slide. So there are 3 types of decisions in the disciplinary process. Go ahead, Sean, to the next slide. Oops, I'm sorry. There's a go back to, thank you. The stipulated settlement. So again, the DAG will assess their ability to prove the charges in an accusation if they had to present this to an administrative law judge. And that's based on the evidence and documentation, the expert reports, the anticipated witness testimony, the licensee's possible or anticipated defenses, and other mitigating evidence and relevant materials. So the DAG will use the disciplinary guidelines to then make a recommendation to executive staff on what they're proposing, how many years of probation, what terms and conditions should be included in that. And then once a stipulated settlement is reached, those are forwarded to the panel members, and they are voting on those, whether they wish to adopt or hold a stipulation for discussion at a future board meeting. There must be at least 2 panel members who vote to hold for discussion for that to occur. A proposed decision, this is if a settlement agreement is not reached, or perhaps the respondent chooses that they don't want to engage in settlement negotiations. They just want to go straight to the Office of Administrative Hearings for a hearing in front of the administrative law judge. So All of the evidence and information gathered will be reviewed, and an administrative law judge will consider all that and issue a proposed decision, which is also sent to board members, to panel members to vote. And that may be voted to adopt or hold the proposed decision for discussion. And if it is held, board members or panel members may non-adopt, adopt with reduced penalty, or adopt with technical changes, or remand back to the administrative law judge with instructions for further proceedings. Also, another type of decision is a default decision. So this is a decision that is rendered after a respondent has either refused to or fails to file a notice of defense or participate in the disciplinary process. So if we don't receive the notice of defense within those 15 days, then a hearing scheduled, they are noticed of that hearing. Sometimes they don't appear, so then the decision is, it results in a default decision. Next slide. So all decisions with the exception of automatic revocations, surrenders of licenses, and default decisions are referred to panel members to vote on, and they may adopt, non-adopt, or reject those. Next slide. So possible outcomes at this point are revocation. And this would require that the individual wait 5 years to submit a petition for reinstatement of their license. They may surrender their license, and they would need to wait for 5 years to petition the board for reinstatement. And 1 year if the surrender was for a mental or physical illness. They may be placed on probation, and this is again in accordance with utilizing the disciplinary guidelines to determine the terms, the conditions, the length of the probation, all of that. And they may get a public reprimand, which again is a letter citing the violation and may include coursework and costs, like cost recovery. In some instances, accusations may be withdrawn or dismissed, and this is where we are not able to meet the burden of proof, or some other information came to light that resulted in that action. Next slide. So there are options to appeal this. Respondent or their counsel may petition for reconsideration if they are dissatisfied with the board's decision or feel that there's other mitigating factors. They may file a petition for writ of administrative mandate in Superior Court to contest the decision. And so the Supreme Court or Superior Court rules on such petitions based on the record of the administrative hearing, including the transcripts and exhibits. And they may remand that back to the board, with their findings. And they may also appeal to the Court of Appeals or the Supreme Court. Next slide. So at the conclusion, when discipline is everything's finally adjudicated, information may be reported to the Federation of State Medical Boards, the National Practitioner Data Bank. The information would be disclosed on the licensee's profile. It would be provided in subscriber alerts that are sent, and it would be included in the board's quarterly newsletter for the administrative actions or disciplinary actions that were taken the prior quarter. Next slide. Go ahead to the next slide, John. So the next area of enforcement is the probation unit. So probation is responsible for monitoring the terms and conditions that have been reached and through the settlement with the licensee. So the probation unit receives the notification of the action, and one of the offices of probation inspectors assigned. They meet with the respondent and conduct an initial intake interview. They're going over the document, what led to them meeting and the terms and conditions that they're required to comply with. When due dates for things, if something's due within 60 days of the decision, that they ensure they understand that. And the respondents then sign an acknowledgement of the decision, documenting they were provided a copy of the decision, the effective date, they're aware of how long their probationary period is, all of the terms and conditions, and that is maintained in their probation file. And so throughout the course of their probation term, however many years it is, if there are course requirements, the probation monitors are monitoring that to ensure they're complying with that. And if not, then addressing that through various avenues. Next slide, Sean. So conditions of probation, there are standard conditions that are included in all of those, notification, obeying all laws, submitting quarterly declarations. And then there are optional conditions. So these might be for substance abusing licensees as an example. They may be required to meet the uniform standards and they must undergo biological fluid testing, or, there are specific terms abstaining from controlled substances and alcohol, things of that nature. Excuse me 1 second. They also have to pay yearly probation monitoring costs. Now, these are in addition to any coursework that they're required to complete. So the licensee is responsible for paying that, and if cost recovery is included, then they're required to pay that as well. And in some instances, that is quite a hefty cost, so they might request a payment plan, and we'll try to work with them to, our goal is to rehabilitate them and keep them on the right track and try to get them to, successfully completing their probation. So we are trying to work with them where we can, and payment plan is something that we can do with them. Also, in some instances, there are requirements that the licensee lets the patients know. It's the Patient's Right to Know Act. Requires licensees on probation for one of 4 reasons to provide notification to patients. And that information is also included in the medical records for that patient, as well as in the probation file. They're required to provide that evidence that they've done that. All right, Sean, next slide. So what happens if a violation of probation occurs? So the probation monitor will look at what's happened. They'll request a letter of explanation from the probationer. So if they failed to submit their quarterly declarations, they'll write to them or communicate with them to ask them, explain what occurred. They also might issue a non-compliance report to the probationer, letting them know, listen, you are out of compliance and you must resolve this within, provide them a due date for them to rectify that. And in some instances, they might request to issue a cease practice order. Excuse me, I skipped over the cite and fine, so let me go back. They might refer for a violation of probation for the citation and fine program. This is not uncommon. I mean, we're doing our best to try to get them on the right track and make sure that public safety is still, there. So sometimes it takes a referral to the citation and fine program, and then that helps resolve that issue. In instances where there's concerns about safety, patient safety, again, we might go forward with a cease practice order. Or if they failed the clinical assessment, then they can't practice, we would want to pursue a cease practice order. And in some instances, we may need to file for a petition to revoke probation as an avenue to try to, rectify and get them out of the practice if there's severe concerns. Probationers always have the option to surrender their license on probation. It's not uncommon. Sometimes we go through this whole process and they just realize, okay, I agreed to all of this, but unfortunately, I'm not going to be able to meet the terms that I agreed to. So they might surrender. They also might surrender for health reasons, or they might be retiring. So they may do that at any point in their probationary period. Next slide. Questions?
So thank you for that, excuse me, comprehensive overview of the board's enforcement process. Are there questions or comments from members for Ms. Smith? Dr. Ayala Rodriguez, we'll start with you.
Thank you so much for the presentation, very informative. About the complaints closed by the complainant unit, about 85% of those are unactionable complaints, and of those, it seems like non-jurisdiction, like it's like quite prevalent. Like I would say it's like about like half of those.
Yes.
Because yeah, so when I look at the non-jurisdiction, for example, I think about like, well, that is a significant reason, right, for closure, about like things that potentially could be done or could be improved. When I go to the website and I go to consumer, file a complaint, there's a very visual sign flag that says to file a complaint against the osteopathic physician and surgeon, contact the osteopathic medical board. But I think that's something that could be beneficial. It's like, for the nurse practitioner, this one. For
Yes.
the PA, this one. Because even when you go into the more information, it says, we have jurisdiction over these ones. For those that we do not have jurisdiction, go to the Department of Consumer Affairs, which I believe that makes the process a little bit harder for a user. But if we already have that flag that directs them to the DO board, I think that's a very, very good visual that could help direct them to the nursing board and to the PA board. Then the other one, it's creating those visuals. Many times, I think that the medical board has done a great job. When you go to different facilities, you always see physicians are regulated
Yes.
by the Board of Medical of California. I rarely see advanced nurse practitioners are regulated by the Board of Nursing, or physician's assistants are regulated by the board of this. So many times people complain to the signs that they see, right? But I don't know if there's any communication like between agencies to create awareness or to create that awareness. Like, hey, many of the complaints that we close are because consumers are confused. Like, let's create some awareness on different sites, different stakeholders, because we're doing our due diligence
Sure.
on the website, on the signs, and things like that. But as a team, as a stakeholder team, it's like, how can we create that awareness? Same thing with the system. I don't know if Breeze has that capacity to transfer a complaint from one agency to the other agency,
Does not.
because okay.
Unfortunately. So if I may speak
Yes.
to that. So it, you may go through the online system and the user is selecting the license type. And unfortunately, while Breeze is a global system, unfortunately, the ability to transfer from us to BRN is not possible. And technically, when the consumer uses the Breeze online system, that complaint is submitted because it's already given a control number. So it's in our system. And so we have to complete the initiation of it and the referral to the appropriate board or bureau.
This is an example. For example, in my organization, we have like different business lines, and if the consumer doesn't know and they go to this branch or this department, it's like, it's not the consumer fault. We know which one is the right one. We just return it to the right one.
Right.
And we already have that information filed. We just notify the consumer, but we don't have them re-enter everything again, because sometimes like you lose the momentum or the interest or the trust into a complaint process. But yeah, so thank you for that. Then lastly, I had a question about the complainant liaison unit.
Yes.
It sounds like we offer an interview when we close, right? An investigation, but I just wanted a little bit of clarification in closure. It seems like closure when there's not going to be an action, but when there's going to be an action, let's say that we escalate a case for a formal investigation, healthcare quality investigation unit, and there's going to be a discipline imposed. Is that something that also gets communicated through the complainant liaison unit?
Yes. So I want to clarify on the interviews. So the statute says, before a quality of complaint within the board's jurisdiction may be closed, the board must conduct an interview with the complainant, if one is identified. So this is important because it's not uncommon for complainants to file their complaint and think, I have this nugget of information, but I don't want to give it up until you ask me for it. We do try our best to explain. When you submit your complaint, we provide an acknowledgement letter that tells you if you have additional information, please provide it. But that's not always done. If we ever have a question in the central complaint unit, we can reach out to the complainant to ask for clarification or, make sure we're understanding what their complaint is. So we conduct, central complaint unit does their full review. The consultant looks at it, they make their opinion on is there or is there not a departure? And then at that point, it's referred to the complainant liaison unit. And this is another opportunity for us to communicate with the complainants, to interview them, to make sure we have all the information we need. And it is, we might learn new information and that's great because otherwise, if you don't tell us, we don't know. And we're trying to make sure that we're having this open line of communication for them to provide us that information. So yes, it's determined that it appears from central complaint unit that there is not a violation to pursue. So it's referred to the complainant liaison unit to ensure that, to conduct that interview, to find out if there's more information. And then if so, what next steps?
And my point was more about like that public trust of like the closing the loop that something happened, right? Like knowing the ultimate outcome if someone was disciplined is like you coming up and bringing up a concern like was meaningful and had an outcome, just the actual notification of.
Yes. So, and as far as the communication throughout the process, so if a complaint is forwarded for investigation, whether that be from the central complaint unit, we notify the consumer that it's being referred and they are afforded the opportunity to provide a complainant impact statement, which will then be incorporated with their file that is then with the health quality investigation unit. So that's huge also because they can let us know how this has affected their life. And it's not uncommon that we get them from multiple family members and we want to know all of that information to have that. So they have that opportunity as well. If it goes to the health quality investigation unit, they may provide the complainant impact statement. If it goes to the complainant liaison unit, there's the interview where they are able to let us know, is there something new or additional that we did not otherwise know up to this point? And if so, what do we need to do? And the complainant liaison unit staff do communicate with consumers about the process throughout. So if it's referred to the health quality investigation unit, they will inform them, it's assigned to the San Jose office and give them that information. If it gets referred to the Attorney General's office, they are notified as well.
But that would be the extent of the communication, right? Like for them to know that the physician ended up with the discipline, they would have to follow the license, get the notification
Yes.
through there, not through the complaint liaison unit. Right? Okay, thank you.
Sorry, just to follow up on that. The complaint tracker system
Yes.
that we talked about yesterday is working, I think, to provide
Yes.
exactly the
Yes, it
The-
is.
a tracking that it sounds like you'd like to see, Dr. Ayala Rodriguez, right? So everyone will be able to follow along and
Mhm.
find out where their
Yes.
complaint is in the process without having to click through and do that
Yes.
manually on their own. Great, thanks. Additional comments, questions? Ms. Remke?
Hi, thank
Hi.
you. I'm just going back to the same issue on complaints closed,
Yes.
and I'm looking at the chart on page 9. And just because there's such a high number closed for insufficient evidence, and then I kind of note also inadequate evidence. So together, almost 2,000 cases there. To me, and maybe I'm reading this too literally, it seems like a legal standard we're talking about. Whether or not they've met clear and convincing evidence, is that the determination being made here, or is it much more clear cut than that?
So the inadequate evidence is we got a complaint against Dr. A. Somebody filed it anonymously. They gave us no patient or any information. If they are not the patient, they didn't provide the patient information. We have no information to know if we could even contact anybody.
Okay, so that's pretty clear cut.
yeah.
Right.
So insufficient evidence is perhaps in a case where we had a simple departure, and that's not enough to proceed with disciplinary or further investigation. So, and also I wanted to be clear, this encompasses all complaints received, not just quality of care. It's all complaints that we receive against physicians for the variety of concerns. It could be about care, conduct. It could be quality of care, all of it.
So then that's interesting. I didn't realize a simple departure would fall under insufficient evidence.
Yes,
So, which is different from no violation, which also
Yes.
technically could be one simple departure, right?
no, if we found no evidence of a departure, then that is why we closed no violation.
Right. And so, again, because it does sound like we're talking about some legal conclusions here, who's signing off on those closures? Or is it, again, just the central complaint unit? Is there attorney oversight? Just what level?
So it is in the central complaint unit for the quality of care complaints. Those are being reviewed by medical consultants. And so they're making that determined on their education, experience, and knowledge of the standard of care. And then that, if the consultant reviewed that complaint and found there was, a simple departure, but not enough for us to proceed, then that would be referred to the complainant liaison unit for them to contact the consumer, to interview them, to make sure that we have all information that we need. And if we have all information, they don't have any new information, then we would proceed with the closure of that complaint. We do have some communications in some instances where we're unclear. We can seek, guidance from a deputy attorney general.
Okay, yeah, I guess to me, it still is not really an insufficient evidence the way you're describing it. It's more of a standard of care issue, but yeah. Uh, and then the other question I had was on investigations, and maybe you covered it and I missed it, but you did talk about the two units, the complaint investigation office, and
Yeah.
I'm wondering what goes where and
Okay.
why.
Okay, so some years back, the board had our own investigators. And then the sworn investigators became a part of the Health Quality Investigation Unit under the Department of Consumer Affairs. So we, at the board, created a non-sworn unit, which is the Complaint Investigation Office. So these non-sworn investigators, they review subsequent arrest reports or reports of criminal convictions. They investigate the vaccine exemptions when we receive notification or complaints that a doctor has submitted vaccination exemptions inappropriately. I just drew a blank. Oh, the end of life option. So if a doctor is handing those out without meeting the requirements of that law, they will look at those types of complaints. In some instances, the criminal subsequent arrest or the self-report of convictions might go to the Health Quality Investigation Unit, depending on the circumstances. Or it could be worked up in the Complaint Investigation Office, and then after all that's gathered, referred to the Health Quality Investigation Unit, and then they pick up. The non-sworn investigators, like, for example, if there's a concern about prescribing, non-sworn investigators cannot go to the pharmacy to obtain the original prescription, but the Health Quality Investigation investigators are able to get those.
So would you say it's different levels of investigation or just different types?
Different types, yeah.
Okay.
And it's non-sworn versus sworn, yeah.
And we have complete control over the complaint investigation office, but limited control over the HQIU. Is that fair to say?
They're under the Department of Consumer Affairs, Health Quality Investigation, yes.
And those people assigned to do it, do they only do medical board or do they do other?
They do other departments as well, allied health, yes. But there are many offices and many investigators throughout the state of California. And yeah, but it's a lot.
I mean, I've discussed this before, I brought it up. To me, that just seems like a problem in the system, and maybe I'm wrong, and I don't know if you can speak to that, but your lack of control over the investigators and them being pulled in different directions seems like possibly some of the delay.
Yeah, so there are some specific boards that have, it's IEU, excuse me, because I can't remember what, they look at the allied health complaints, some of the allied health, but I can't speak to how HQIU assigns, but they have Miss Whitley is their deputy chief. You know, she's the oversight right now for all of the field offices. There's commanders, supervising investigators and investigators. So there's many layers and watchful eyes on what's going on with those complaints. And but IEU does handle some of the allied health complaint investigations for health quality investigation.
Well, maybe this isn't a fair question, but in a perfect world, would you prefer to have the control of those sworn investigators directly under your?
I can't comment to that. I mean, that is how it was, and then there was changes made, and
No, I don't
you
know
know,
that history.
yeah.
So to me, again, just looking at it from the outside, that seems like a flawed system. To have someone not under my control
Right.
who's handling my investigations.
Well, we do review their investigations.
But I'm
We-
saying,
yeah.
hey, I need that one now. Don't, you know what Okay, well, I'll let that go. And then my last question, I think right now, is it's kind of the same issue. It's once we refer something to the AG's office, you talked about the discipline coordination unit, which I guess I did not know. And I'm wondering what really, a little more understanding of their role, because once again, it seems like we lose some control, a lot of control over these cases once they're referred to the AG's office. And as we know, when we look at the number, that's where so much time is spent on the cases that are ultimately sent, accusation and a conclusion. So is that the role of the discipline coordination unit, to watch that timeline, to?
Well, they can't control the time, but they're in communication with the DAGs. And they do have information on what's been referred and, anticipation, and we keep track of statutes and things of that nature so that we can keep an eye on that, because we don't want it to just be lost.
Right, right.
But discipline coordination unit kind of liaises between the Attorney General's office when, the investigation is complete. It's then referred to the Attorney General's office. They're looking at it, conducting their legal review to determine what next steps. And so the discipline coordination unit is kind of processing that once that comes back.
I guess I just point some of this out because, we get a lot of grief from the public about timing on some of these cases. And when you really look at the system, some of it's out of our control. And it looks like at some points it was under our control and now it's back out of our control. And I guess maybe some of my questions would be for the AG's office, because when you break down from yesterday's numbers about the hours spent in the AG's office and the number of cases they have, quite honestly, I was shocked how little time is spent on each case if you break it down that long. So I'm not sure, do cases just sit there for a long time before the DAG has time to get to the case? And you
I
probably
mean, I
don't
can't
know
really,
it.
I can't speak to their process.
Again, we just know it's
Yeah.
a lot of
Yeah.
time in that office before.
Right, a lot of moving parts and moving of things, and we're doing our best to make sure we're keeping that, because it's patient safety,
Right, right. So, okay, thank you. That's all I have.
Dr. Sai, it looks like you're not getting ready to do something. Other comments, questions? Dr. Mahmood?
Yeah, I have a little different question about this probation officer or practice monitor. Is there a guideline that who can be a practice monitor? A person who is on probation, his partner, or guy, his friend, or other? Because a lot of people, this question I literally get every week.
Mhm.
Who can be? And is there a guideline for that? And
So the probationer may submit their app, who they're requesting be their probation practice monitor. And the probation unit will look at that. Obviously, we want to identify those kinds of conflicts, because we don't want to have your best friend, monitoring your.
no, I know
Yeah,
that, I know
yeah.
that, but what is the guideline before they even pick somebody? You have I can't find any guideline, 1, 2, 3, 4, 5, 6. These people cannot be your practice monitor. So they don't waste time. That's why they keep on calling us and kind of stuff. So if there is a guideline, okay, these are the things you need to pick this kind of person. So they don't come with the practice partner, they don't come with a friend, they don't come with a relative.
Right, right.
So if there is something we can have, and
Okay.
actually all the board members should have, because
Okay.
I literally get every week this question, oh, can my partner can be, and there is nothing information out there.
Yeah.
So before they go and waste time, find somebody, commit somebody, and we say, okay, this is not appropriate. So that process is already streamlined.
Thank you. I will look into that.
Thank you.
Additional comments, questions? We'll go to Mr. Watkins and then Dr. Thorpe after.
I just have 3 quick questions.
Yes.
I like the presentation, by the way.
Thank you.
Makes me feel like you're moving in the right direction. And my first question is the complainant impact statement.
Yes.
I think that is a great tool, but I think we as the board, like say in the panels, that would be useful to add some balance to that conversation. And I'm not sure if there's authority for us to see that complainant impact statement. Maybe you can shed some light on that.
I'm not sure if that is included with, I don't believe it is. And also, just to be clear, that just started when that law went into.
Yeah.
Yeah, so it's not been, cases you might be coming before the panel may not be cases where that was in effect. So, Carrie
Yeah,
can speak on
I'm
that.
happy to assist with that. That is pretty new and not everyone submits an impact statement, but for those that do, that statement will be included in the materials for the board members to consider when they vote on the matter.
Oh, awesome. And I like that a lot. And I also like the fact that, you know, some of the things that you've mentioned about what the enforcement monitor and now the new collaborative efforts, you basically answered all of my questions because now you have an opportunity to show me something different, not me, but the public.
Yes.
And just a clarifying question just to clarify upon the question Ms. Remke asked, the medical consultant signs off on that, right, in the CCU?
Medical consultant renders their opinion based on the
Renders-
information.
The final sign off in that line, is that the chief or another supervisor?
It's a
No.
manager and the complainant liaison unit, and the deputy chief oversees the complainant liaison unit.
So basically, 3 people sees that complaint and they all 3 agree that this is the right decision.
And we also collaborate with the deputy attorney general that
The
works
CCU?
specifically. Well, CCU does, yes, but separately from the complainant liaison unit, there is a deputy attorney general that they work with and meet with regularly to discuss.
I just want that CCU component, right? So on the CCU, when we close an account or when we close a case, so medical reviewer, he signs off on it, somebody else reviews that and then signs off it. Who's that? Is that the chief or a supervisor? Just in the complaints here, central complaints here.
Well, the central complaint unit, if it's a quality of care complaint and it's went through consultant review, it's not closed because we can't close it because the statute requires that it goes to the complainant or the complainant liaison unit.
Oh, so now it goes over there.
Yes,
Okay, so now it gets even more interesting
Yes.
because now there is another process of oversight. So the
Right.
central liaison unit now gonna have its own data for us to be able to review how good the system is working.
right. So again, the complainant liaison unit will contact the complainant to schedule the interview,
Yeah.
which could bring additional information that we did not otherwise know. And so that could go another avenue. Or if there's no additional information and the consultant rendered their opinion before it was referred to the complainant liaison unit, and we get no information, no additional information to, continue with our review, then the complainant liaison unit would close that complaint.
Awesome. My final question always ask me, and this pertains to, do HQIU or the unsworn investigators investigate the substance use cases? I'm always unsure about who investigates those cases.
They both could, because the complaint investigation office could receive the current record of the conviction or the subsequent arrest report, so they might start that review, and like, for example, if it was an arrest for DUI, or a conviction for a DUI, then the Complainant Investigation Office would be initially reviewing that. There might be some exceptions to that. And the Health Quality Investigation Unit could get that also, you know, if maybe there's already a complaint that they were investigating on this licensee, and then we receive the notification of the arrest or the conviction, we would probably, we would refer that to the Health Quality Investigation Unit to work along with the case they're already looking into. And then they will gather their evidence and conduct their interviews and, you know, obtain the records necessary, complete their investigation and determine, you know, we'll review that. Myself and the deputy chief will review the Health Quality Investigation Unit cases to determine if transmittal to the Attorney General's office.
So would you say mostly HQIU then?
Yes, probably.
Okay.
Mhm.
Thank you.
Dr. Thorpe?
Thank you. So I want to go back to what was brought up by Dr. Ayala Rodriguez about the problem with complaints complaints being entered and not it being in the wrong place.
Yes.
I mean, it seems like such a common sense thing to, at that point of entry, to divert them to the right place rather than to go through our process, clutter up our numbers, and create a diversion. Really, it's like this bizarre thing. We've got all these complaints and none of them are any actions are on. We only act on, like, you know, of the 7,589 complaints that you've listed here, we don't act on any of those. We act on like 600 complaints, maybe out of the whole thing. It just seems kind of odd not to, in today's world, when you said that, well, this is what you kind of, my hearing is bad, so maybe I just didn't hear you, but I thought I heard you say, well, that's just the way it is. We can't really fix that. Is that true?
Yes, Breeze is a global system used by many Department of Consumer Affairs agencies.
Okay, but any system can be fixed. I mean, I know that's the way it is, but what maybe the question is, what do we need to do as a board to fix it? Because that's kind of what we're supposed to be doing, is helping to make sure that things are better than
Sure.
they were.
And I understand your point, and I do want to let you know that that's easily identified. Like, you know, we all see a white coat and we think doctor, but it could be a nurse, it could be
Right.
PA. So those complaints, particularly the online complaints, it's already initiated a complaint number. It's already in our system. So we retrieve those, we complete the initiation and refer them on to the appropriate agency timely so that and we notify the individual that that's been done. I understand, and I would have to defer to DCA and possibly Sean on, it might be a request we have to make, and I'm sure other agencies probably feel the same way if they're receiving, like Osteopathic Board is receiving medical board complaints. In a perfect world, it would be lovely to just click and reassign it, but the system's not set up for that right now. I don't know what would entail to get to that.
Well, I guess that, to me, that seems like a worthwhile thing to do
Sure.
to try and improve workflow. And so I don't know what we need to raise that with, but Madam President, but I would recommend that we at least pursue trying to streamline this process so that we are not, it does take some time for you to do that. It's
Yes.
maybe not be very much, but
Sure.
it's something.
Yes.
And if it was automatically diverted to them rather than having to come to you,
Mhm.
you don't even get a complaint number till it goes to them.
Right.
They get the complaint number. So I would just say if there's something we can do to address that, I think that makes great sense. And I appreciate Dr. Ayala Rodriguez for bringing that up.
Thank you.
Yeah, so I don't know the answer, right now to the question about who has responsibility for helping us make those changes. It would seem to me, though, that as part of our sunset report next year, this is the type of issue that we could identify in the sunset report as something
Exactly.
we are requesting to be fixed. Frankly, just like we did with the complaint liaison unit, complaint impact statement, that's where those ideas came from ultimately. And so it would seem to me to be this sort of thing. It is not uncommon in the California state government for these inefficiencies to exist. So, but I do think there's an opportunity for us to improve on them, or at least make the suggestion and continue making the suggestion until they get resolved favorably.
In that same regard, I have several questions. If you want to take somebody else, that's fine.
Why don't you finish up?
I just want to also pile on to Ms. Remke's statement of the inefficiency of our process. And I know, prior to my being on the board, there was a vertical enforcement process.
Yes.
And there was a reason why it was broken apart. I don't know the reason personally, but obviously there was some reason because it was done. I think it would be instructive for our board to know what that was, so we don't keep saying, well, this is ridiculous. It's very inefficient. I appreciate the collaborative process you guys are starting, which is a sort of a mini step towards vertical enforcement. It's not the same, but it's something, and that's an improvement. Clearly, the enforcement monitor recommended that we go, what really his recommendation was, you go back to vertical enforcement. That was what he really recommended. But of course, we haven't done that and can't do that without something in sunset review. So I also would say that we ought to at least look at that in sunset review as going back to whatever was wrong with vertical enforcement before, we consider getting that fixed and putting things back together again, although Humpty Dumpty never can put whatever together again, if you know what I mean. You look like you're going to say something, Madam President.
I was just going to say, I was here when vertical enforcement, not in this role, so I'm not sure as to the reason, but I do know with this collaborative process, there will be more work with the deputy attorney generals and the investigators throughout the process and the selection of the experts and, the interviews and all of that. So that's going to be huge and helpful in helping to make sure that it stays on the right track and avoids those supplemental investigations or, rejections because there's a problem, so I'm hopeful and we all are hopeful. We don't say vertical enforcement, but we're trying to, we're looking forward to this and seeing the results from it, the improvement.
Oh, I'll look forward to that too. I have a couple more things. Sorry. So I want to just go back to, as you're doing the investigation,
Yes.
as you're determining whether there is a simple or a extreme departure, that is simple negligence or gross negligence, who makes that determination?
So when those are in the complaint investigation office or health quality investigation unit, that is determined by the expert reviewer that is assigned to review all of the information that is gathered throughout the investigation to that point.
So the expert reviewer, how do they determine gross negligence? Is it just like a feeling like, oh, this is really bad? Or are there actually metrics that they go by to say these things are gross negligence, these things are simple negligence? You have to have two of these things to be able to get a complaint.
Gross negligence would be something where there's an evidence of a lack of even scant care, something that's.
Okay, I understand that definition, but when I see the complaints, that's never the case. Never the case. There's gross negligence. It's bad. I'm not saying, but there's not even scant care. I mean, there is scant care. It's not that my concern is that we don't have a very good definition of gross negligence. I think it's a significant problem.
Well, there is a definition and the expert is making that determination based on their education, training, and experience. And so, and experts can disagree.
My point. Yeah. And the question I have, I guess, is do do we train them, the experts? I know that that definition, but it's so vague. It's so incredibly vague. I mean, you could push that scant care means you didn't put a Band-Aid on them even, you know, I mean, it's kind of, anyway, I don't want to get off on that. But I did want to understand where that comes from. I appreciate that. You also mentioned, can I go back to another thing? You mentioned your goals for the, I think it was for the,
Collaborative process.
collaborative process. And I wondered if you were talking about that you thought it would improve processing times. And I wondered if there were any stated goals, any visionary goals, any any potential goals that you might achieve, you know, any not achieve, but any goals that you might that are aspirational in terms of what your processing times could be improved to. Was that looked at, or was that even stated, or?
Not specifically, but there are timelines as far as the collaborative process from, you know, when a case is referred for, and it's a case that, case category for the collaborative process. There's timelines for the DAGs to meet with investigators, the follow-ups, things of that nature. That's part of that process will be the constant communication and timeframes for these things to occur, which will then help to improve the processing timelines.
There, you know, we all set goals. Sometimes we set goals that are so easy to meet that we don't have to worry about missing them, you know. Sometimes if you do that, you don't make a lot of progress, but if you set goals that are aspirational, you tend to get further when you do that. And I would just encourage you to look at aspirational goals, where we are today.
Sure.
How could we decrease that by 30% or 20% or whatever? I'm not sure what's reasonable, but you understand what I'm saying?
Yes, I do.
Okay.
Thank you.
And then that's all. Thanks.
Thanks, Dr. Thorpe. Additional, Dr. Yip, did you want to weigh in?
Yeah, a few comments, questions. I'm a poor historian, but I've been here for long enough to answer some questions for the member, which questions are excellent, raised by Dr. Rodriguez, Ms. Ramke, and Dr. Thorpe. First, we do have a conversation with the president and the management team a few weeks ago about how do we make it easy for public to access the proper agency. And we probably need the DCA, the deputy director sitting in the corner, to help to create a system that in the world of AI, IT, we should be able to do that if you put the name of the healthcare provider, and that would automatically help you to divert the link to the proper agency and get a response to them so that they would not have a problem who's the MDDO and MPPA. So we did touch on that during a working session. But we can expedite that request with the DA's help, the DCA help. Second is the question is that I think there's a trust issue and not just personal, like, does the system work? Who make the decision? Who signed the case? Is there appeal? If you sign it well, it's not an issue that we bounce it back to the public. Is a channel for them say, I don't like your decision. I want a second medical concern look at that. I want a second more evidence collected or another call with the staff. Probably in the future, 3 or 6 month, 2-board meeting, we may have more detailed analysis of those so-called sign-up cases, what they are and what's the nature. So at least the board member, the public feel, we trust you. I talked to Reg a few times how those cases being signed on, but I think the public and the board would like those data just to educate ourselves that we're on the right track. Like, you may be retired next year, we may have somebody else we don't trust, but we want a system to be there that would carry the same high standard of care job. And back to the vertical enforcement, etc. I was at the time that actually there was a discussion about probably the internal investigator not doing a good job. At that time, there was a legislative move to move the investigator to the actual Department of Justice, and subsequently, surprisingly, moved to DCA, HKIU. And that goes through a number of years of high vacancy, and that contributed a lot of delay in the investigation. I think at one time, they were like 25% vacancy
Yeah.
until 6 months ago down to maybe 10% or less. So that's one of the things. So whether we can do our own investigator, the question is that would other agency or the public feel our own investigator doing the job? I think one of the reasons go to HKIU, they have a number of investigators, but a number of them would have a heavy load of medical board cases. So it's like you're hiring someone, but then outsourcing, but they do more for us. So the other history is that the vertical enforcement is more like a term. I talked to Reggie a few times too. It's more like how you do it. When I was involved in enforcement years ago, I actually flew up here a few times just to sit on the collaborative meeting, just like you're saying. The deck is there, our staff is there, the investigator there. Whatever name you call it, is the effort that make matter, okay? And I think now I talked to it a few times, you do have very frequent meeting with the deck. I agree that that should be brought in early in the case so that you have guidance, how to do it right, how to do the collection of evidence right. I think more like a process that make matter rather than the name. There's also the question about the who would be fit for the site monitor. I think there's some written criteria there that you should not be a business partner, should not be a formal relations, etc., no conflict of interest, etc. So I think you're doing a good job, and Reggie's working hard, and our president, great leadership, but we do need some help from DCA to create that click that is easily used by the consumer.
Yes.
Thank you.
Thank you.
Additional comments or questions? Excuse me, Dr. Mahmood.
Final thing. All this process is to, number one, keep Californians safe and secure, but also to have the public's confidence on the board is doing the right thing. So closure, I want to come to the public now. The closure, when you do it, obviously when somebody's license is revoked or probation is done, they are informed. But are we keeping the complainant especially informed about who is being on probation, how we are monitoring probation, and when they apply for early termination, to keep them informed what is going on so that they know that we care about that. We go through the due diligence process. And until everything is completely closed, keeping those complainants at least in loop, what we are doing, so that we are also satisfied, that public is satisfied with our work.
I'll start with the central complaint unit first. So we do have notifications that are sent out when we initiate their complaint, acknowledging that. That's sent out. And when we request information, we have an introductory letter that we send once the complaint is assigned to an analyst in the central complaint unit to let them know, hey, I'm your point of contact. And we may or may not need to request information. There are some instances where we do have the releases we need. So we'll let them know, I'm your analyst. You've provided this. This is what we're doing. And then once we've obtained the information and we're referring that for consultant review, they are informed of that. And if when the complaint is reviewed by the consultant, and if the consultant does not find evidence of a departure, we notify them that it's being referred to the complainant liaison unit, and then they reach out to coordinate and schedule the interview. If the complaint is referred to the health quality investigation unit from the central complaint unit, there's a letter informing them of that and also letting them know that's their opportunity to provide their complainant impact statement. I can't speak to the communication beyond it leaving the medical board and going to health quality investigation unit. But, if you're going to interview, I've read many of reports of investigation where the investigators reaching out to the complainant or the witnesses to, get their information from them. So we do our best to communicate with them throughout the process. I don't know once probation is issued. I'll have to look into that if there's, communication. I do not believe if someone on probation petitions for early termination, I do not believe that the individual is notified. I can clarify and let you know that. But the information about their probation and all that would be on their license profile, what the length of it, the terms and conditions. If we file an accusation or accusation petition to revoke against the physician, that would be disclosed on their license profile. It would be put in subscriber alerts. However, if that complainant doesn't subscribe to those, then I don't know that there's separate communication sent to them to inform them of that.
I really want to compliment you. Great work and great
Thank you.
presentation and step to the very right direction. Thank you.
Thank you. I appreciate that.
Additional comments or questions before we go to the public? Dr. Yip?
One last one. Regarding Dr. Thorpe about the standard care, when we have in-person training for expert, we actually spend an hour to learn what is the standard care. It's always a little struggle, different specialty and all that. So we do have a online module now. So maybe the board member interest can get on the module and study it, learn about it. That would be helpful too. Thank you.
Yeah. And I would just like to say that, I appreciate all of the staff in the various units of the enforcement program for all of their hard work, their input, their, agreement. Maybe they're taking on these changes, they're rolling with the punches, and we can't be successful without their, contributing to that. They're a huge factor. And I just want to acknowledge that and appreciate that it's all of us working in collaboration, and our leadership is extraordinary and guiding us into a better outcome.
Thank you. Okay, let's open up for public comment. Any public comment from those in the room? All right, seeing none. Sean, if you could open it up on WebEx, please.
Yes, if you'd like to make a public comment here on agenda item number 10, please do so by raising your hand or typing anything in that Q&A window. First up here, we have Michelle Montserrat Ramos. You should be receiving that prompt.
Hi, Sean. Can you hear me?
Can Michelle, please go ahead.
Good morning. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. Under your triage process, you state complaints that warrant immediate investigation include a high priority urgent complaint is sexual misconduct and physician impairment, such as substance abusing doctors. What happened to death? If your plan is to eliminate the need to review substance abusing doctors and potentially discipline them, then what is exactly left in terms of the high priority complaints? I also would like to know if a substance abusing physician complaint is referred for immediate investigation, then what happened to my complaint on behalf of Lloyd Montserrat that was closed at the Central Complaint Unit? In regards to missing medical records, release signature forms, I've had families file their complaint having signed a release form and are still asked 3 times to resubmit the same form. Under the Complaint Liaison Unit, you state that CLU staff offers interviews and quality of care cases before closure to complainants. Interview ensures the board has all necessary information from families before making final determination. This is the exact problem we were speaking on during yesterday's meeting. This is exactly what happened. The CLU rep did not tell the family that this was their final interview. When I asked the rep 3 times if this was the final required interview before their complaint was closed, she told me no 3 times. She asked 2 incredibly generic questions, with one being so outrageous that you would never ask a family whose family member died so tragically needlessly. We were told that a supervisor was on the call with us, and the supervisor did not utter 1 word during this meeting or in response to the questions. 3 months after this meeting, where it was explained to us that they were just gathering additional information, this complaint was closed. When the family received their complaint closure letter, they were not offered a final interview to try to resolve their complaint. This is not what the law we advocated for in the Sunset Bill requires this board to do. The information in these materials shows us that this board has not been conducting final interviews as the law requires. Your board staff misled this family, basically lied to us, and that is unethical and not following the law. You must change this process to adhere to Business and Professions Code 2220.1 B1. I don't know how much time I have, but in reference to some of the questions, I've had a family refer their complaint to this board when it needed to go to the osteopathic medical board, and it took 3 months for that complaint to reach the osteopathic medical board. I've been doing this for 18 years. I work with a lot of families. We really need more than a 3-minute comment section, and I really hope that we will plan some kind of enforcement meeting or something so the board and can hear from the public, because the public has a lot of input on this issue. Thank you so much.
Thank you for your public comment. Next here we have Marion Hollingsworth. You should be receiving that prompt. Morning, Marion.
Hello, I'm trying to find my,
We can hear you.
here, hold on. Stand by here. Here we are.
We can hear you fine, Marion.
And okay, thank you.
Please proceed.
Okay. Good morning. My name is Marion Hollingsworth, Patient Safety Advocate. I was hoping you could explain how you give more attention or act more quickly with egregious cases, because I don't see that happening unless there's a suspension, and even those are rare. I read or at least skim through every accusation and decision. The egregious cases seem to be given the same timeline for accusation and even additional time for a decision to be reached. As Dr. Thorpe just called it, the inefficiency of the process. It took you a full 3 years to release an accusation for Dr. Carlos Chacon, whose cosmetic surgery patient coded. He didn't even call 911 or render aid himself for more than 3 hours while he saw other patients. There are currently several pending sexual misconduct accusations in which the doctor is continuing to practice unfettered with no notice to patients. One doctor who was recently revoked a full 2 years after his accusation was finally posted. It took you 2 years. He had lured a caretaker to his office and assaulted her. You allowed him to practice again for years after you knew he was dangerous. The same with Chacon. You knew he didn't have a license anesthesiologist or CRNA, and you let him practice. How do you explain that? It shouldn't take 4 or more years to discipline a doctor for sexual misconduct or preventable patient deaths. The issue of having some sort of notice on the doctor's profile page has been discussed, but nothing has been done so far. This would notify the public that the doctor is being investigated, something that the contractors board has been doing for years. Now, I totally understand the due process issue with your investigation. However, the board keeps forgetting that your purpose is to protect patients. My question for you is, how can you move up the timeline on these egregious cases so patients aren't at risk for years while you give the doctor free rein through due process? I know you usually don't answer questions from consumers or advocates, but I'm hoping you will answer this time. Californians deserve better protection from dangerous doctors. It's unconscionable for this board to knowingly allow a dangerous doctor to practice without a warning to the public. And again, I hope you answer the question on how you can expedite the process. Thank you.
Thank you for your public comment. Next here we have Rob Gordon. Rob, you should be receiving that prompt. Morning, Rod. Your line's open. I saw your line open up there, Rob, but we can't hear you. So if you have a secondary mute or something like that, you have to take that off. We'll come back around. Marcus Friedman should be receiving that prompt.
Good morning, board members. My name is Marcus Friedman, Administrative Director for the Consumer Protection Policy Center at University of San Diego School of Law. CPPC is in support of this board's discussion about finding more streamlined processes for enforcement proceedings. As some board members have mentioned, timing is one of the major issues highlighted by the previous enforcement monitor. Vertical enforcement should be a priority in restructuring enforcement proceedings, as having an AG prosecutor assigned to the case and advising investigation will help decrease time delays. CPPC encourages this board to pursue options and meet with the DCA, AG's offices, and the legislature to discuss how to best streamline these proceedings. Additionally, CPPC would be willing to help draft legislation and join discussions to address this issue. Now is the perfect time to address these issues ahead of submitting the Sunset Report for next year. Thank you.
Thank you for your public comment. Try Rob here one more time. Rob, you should be receiving that.
Sean, are you able to hear me this time?
Yeah, we got you, Rob. Thank you.
Yeah, I did not hear the presentation, so some of what I say, I'm not really informed on the what DCA just was reported on. But you don't get any calls when you file an investigation at all. Now, I've already tried to tell my story. I doubt if anybody listened. But I had a woman just go off on me after my own psychiatrist left. They later, my real psychiatrist left Family Health Care Center to San Diego. And they threw me into unsupervised withdrawal from the medications they had prescribed. When I finally got talked to a psychiatrist, she just started screaming at me. I won't go through the whole thing, but it was an entrapment into using, saying I used cannabis. Immediately got given a disorder, cannabis use disorder, which I don't even use cannabis. There's so little. I didn't have that. And that you're supposed to support it as a problem anyway. Anyway, whole process. That guy later claimed he was her boss put her up to it in retaliation for me mentioning an earlier situation. Later, they framed up my psychiatrist for a suicide. A trans woman threw herself off the parking garage in downtown San Diego. That they called in their court. The court proceeding, they called that person mother of patient B. She called me after the process. So I'm not just talking about myself anymore. And they hadn't talked to her. You guys spent $100,000 on that at least. And that's not why she filed the complaint in the first place. She was constantly saying, I don't want Dr. Urbe to lose her license. So you've got a completely warped process. I've got so much to say. It just kind of comes at me from all directions. But information would save you guys. You know what to do. I'm not going to go through it again. This could be 70% of your problems could go away almost instantly. But this isn't what was supposed to happen. So anyway, I'm not making any sense. I'll let someone else talk.
Thank you for your public comment. Next here we have Maria Ibarra Navarrete. Should be receiving that prompt.
Yes, good morning. My name is Maria Ibarra Navarrete. I am from San Jose. I'm also a volunteer with Consumers Watchdog. I don't see the patient impact statement anywhere here in your presentation, though it was discussed because other doctors brought up the discussion. So I want to thank doctors that did bring this up, especially Dr. Rodriguez, and asked about it. According to the Business and Profession Code 2220.2b, this board is required to provide the family an opportunity to describe the harm they experience and the impact to the family as part of a complaint to this board once the complaints are referred to investigation. I was one of the members of this team that advocated for this patient impact statement. Why is the patient impact statement not referenced in this presentation on the enforcement process? Are you actually offering families the opportunity to provide you with the patient impact statement? And how are you doing this? Under these types of violations, you must really tell us exactly what you need to move a complaint forward to investigation. You mentioned gross negligence, an extreme departure from the standard of care, and you mentioned how many extreme departures from the standard of care our complaints need to go to investigation. Yet, you have not stated how many simple departures from the standard of care are needed, or a combination of both. The public needs to be told how many extreme departures from the standard of care, simple departures, or a combination of both do we need to present to ensure that our complaints have a chance to be referred to investigation. This information that you can put into your how to file a complaint video on the information can be on your website. You mentioned the doctor's appeal options, including petition for reconsideration. Where is the public's appeal process for a complaint if they do not agree to it or if they have new evidence to present? we can't find it on your website. Are you telling us that only doctors have the right to appeal, but the public does not? Thank you.
Thank you for your public comment. One more here in the Q&A. Susan Sykes, I'll be sending you a request to ask your question.
Yes, good morning. Can you hear me?
We can, Susan. Please go ahead.
Great, thank you. I am a physician who lost a colleague in the last year who was in process with the medical board. And I hear and totally appreciate the consumer and patient perspective on this. And I've had family members also impacted in similar ways. But my point has to do with the concern that there is, in a process that is complex and bureaucratic, that there is collateral damage, which is an understatement for what happened with my colleague. What my question really is that the board address how social media is utilized in this process of enforcement. My colleague had no patient or practice issues at the time, and his privileges were suspended. He was unable to practice. That was a collective decision made. So he did not present at the time any danger to the public in his practice. And the full complaint, greatly detailed, was posted on X, on Facebook, causing great harm both to himself, who is no longer with us, and his family. And I think that the board really needs to understand that social media is a crude tool and needs to be used in a nuanced way, certainly to make sure other members of a particular doctor's practice are aware there's concerns about them. But when that person's practice has been suspended and they are no longer practicing, 4 to 5 page detailed, not gone through the full process yet, should not be posted in such a way that the harm to family and self is so dramatic. It really prevents doctors and other healthcare providers from seeking help when they have either complicated medical conditions, which was this person's issue, or mental health disorders. We want providers to be able to access support and not be shamed and closeted when they do need help. The public is also not served well when we lose providers who could be healed and rehabilitated. Thank you for your time.
Thank you for your public comment. At this time, there are no additional requests in queue.
Thanks, Sean, and thank you to the members of the public for your public comments. Are there any further comments in the room? All right, seeing none, any further comments or questions from board members? Dr. Thorpe?
Sorry, I would just, in response to a couple of the public members' concerns, and I think it would be wise to have another public stakeholder meeting next year, earlier in the, sometime early in the year, to address some of these more detailed issues that we can't really respond to here at the board. Thank you.
Thanks, Dr. Thorpe. Any additional comments or questions? Okay, we'll move on to agenda item 11, which is a presentation on the board's enforcement data. Mr. Varghese?
Thank you, Madam President. This will be a very quick update. Sean's going to run the PowerPoint presentation from back there. So as you would see in the agenda item 11, the staff memo, the purpose of listed under the staff memo is to highlight how the board presents enforcement data, including the slight variations or differences between the numbers reported within those publications. Also, the staff report addresses concerns related to the volume of complaints that are closed without discipline. Again, I probably will not spend too much time on it. I think we had a lot of discussion on it already. So, before I start on the PowerPoint presentation, Sean, there's a lot of feedback. I don't know.
I'm saying, is there, oh, now the feedback's gone. Got it. Well,
I'm not ready for Q&A at this point, so.
what's, it's,
Static.
it's back. We know what's happening with that static?
Wrong.
But are both mics off now?
Okay, that's better. All right. All right. Well, so before we start on the PowerPoint presentation, I just want the board members to keep in mind that each report that are presented to the board, like during the quarterly reports, like Q1, Q2, Q3, Q4, and also the annual report, they're all like a snapshot of the data at one particular time, right? So, and also listening to Ms. Smith's excellent presentation there, you probably got the idea that from the time a complaint is arrived at the CCU to all the way through its life cycle, there are a lot of data entry points the staff will have to make, the coding, what we call it. So again, those codings sometimes can start with one coding, but in Q1, say for example, but going through Q2, Q3, it could change because something happens to that complaint. Some changes happen, or we have weekly and monthly metrics reports and error reports that are automatically emailed from the BRIES system to the supervisors for quality review and quality check. And they will, in that audit process, may find that a data entry error was made. So they will go back and correct it. So a total number of a number that is reflected maybe in Q1, the error was found in Q2 or Q3, they will have to go back and fix it. So just keep that in mind as we go through this process, which is very common that many industry, even in accounting, that is the reason the accountants perform trial balance checks every week or month before they go into financial statements and balance sheets, right? So to find those errors on a timely basis before we get into the year-end financial report. So let's move on to the first screen there. So this is a portion of the August board quarterly meeting material referenced in staff report for today's agenda item 11. This display of data for those with physicians and surgeons license includes outcomes that are a result of a probation violation. Notice the red circle. I'm not sure if it's visible from this head table. Okay, red circle there around that number 88. On the row that says license surrendered in lieu of acquisition or acquisition pending. As I move to the next slide, just keep your eye on that one. So let's go to the next slide, Sean. Thank you. So this is a report displayed from the most recent board's annual report of 24-25 annual report that was published, and which shows outcome related to probation violation in separate tables. The two numbers in the red circle add up to 88 on the previous screen, which is the same number that you saw on the quarterly report meeting material before you saw that is reflected in one screen. Let's go to the next screen. So this is the same number of surrenders as displayed on page 18 of fiscal year 24-25 board annual report. But in this table, those numbers are indicated by case type based upon the primary violation code of the related complaints. So multiple reasons why information is presented in a certain way or this way in board annual report, which is a requirement of the law, noticeably Business and Profession Code 2313 and Business and Profession Code 2220.05C. Also decisions of prior board leaders and the executive staff, and those sort of shape the annual report content. Let's go to the next screen.
I'm sorry, Reggie, I forgot to activate the share outside. Do you mind if I just go back and show those screens real quick? My mistake. This was the first slide with the original
slide.
88.
Okay. Yeah, second slide. Yeah, with the 60 and 28, that adds up to the 88. Okay. All right. Okay, this is fiscal year 23-24, which is previous fiscal year DCA annual report, page 109, that reflects medical boards. DCA is still, I don't think they published the 24-25 annual report. So this slide shows an excerpt from their report that shows that DCA combines all license types when reporting discipline. The board reports discipline related to information for those with physician and surgeon's license on page 16 and 19 in the 24-25 annual report, and all combined allied health license discipline is reported on page 21 of that same report. Let's go to the next screen. So again, this is like number reflection of the same graph that Shar presented. This slide shows the various complaint closure data published in the board's annual report. So I'm not going to spend too much time on it. I think we had a lot of discussion on it. So let's go to the next screen. That's same pie chart on the next screen. Again, I don't want to spend too much time on this one either. I think we had a lot of questions. So that's pretty much my brief report. Any questions that myself or staff can answer?
Are there any questions, comments from board members about how our data is presented? Mr. Watkins.
Let's track them. No, it's
Yeah, there's static there, so just switch the mics back. So or use the, yeah.
happy. Oh, there you go. Yeah, I have a different view on this numbers. And I want to, whenever I speak, and it's a tough subject, and I want to make sure that, this is received. I'm here in the spirit of making this better, bringing information in a way that is clear and actually speaks to what we actually can measure. And there's standards for that. And this is not a assault on Mr. Varghese or anything, because by all counts, he's doing his best. But there's a fundamental error happening in these numbers, and Mr. Varghese will confirm that. And that is, we are combining two, and I'm going to read from this because there's too many thoughts in my head today. I'm just having a little bit one of those days in my life. So the first issue is that this presenting the numbers like this, we're combining administrative actions with probation violation actions. And that is just not correct, because administrative outcomes, that is discipline generated in 1 year from new cases. And they from 1 fiscal year. So they provide a kind of a real view on what is happening on the board for that year, right? Then the probation violations that is added into that makes the big number. Those are disciplines that are generated from old cases, old administrative cases in prior years. they originated in prior years. Okay, so whenever we do that, when you mix these things up, what you find is you inflate the current year probation, you inflate the disciplinary numbers. And I'm going to show you how significant this is. You inflate the current year with cases that have nothing to do with this year because they originated in a prior year if it's probation violations. So now what you're doing is you are blending two entirely different pipelines, if you will. And when you blend this is like the one process is new accusations, new discipline, and gives you a metric, this year's performance. And it's a lower number, right? And then you bring in old cases, monitoring failures, because it's a probation violation. So these folks that were on probation are now failing that probation. And then the probation violation is filed, and then an action is taken in this year. So what happens? This year metric is now, this 1 year's metric is now turned into a multi-year metric because the numbers stem from previous years. And now it distorts everything. So here's what the mathematical distortion is pretty significant. Let me explain to you. I've done all the analysis. I'll share I'll share this draft copy that I wrote, and I'll share the information because it's interesting. What this revealed was actually more interesting for me and for the board because it gives us something to work with. Questions we've all had at one point or a time. So it's to make us all better, you know. And so a quick analysis of the data. And I did this from financial year 14-15 to 24-25, the last 10 years. So what I've seen, probation violations contributed between 5 and 10% into total older years for the financial year 14-15 to 21-22. And in the last 3 years, 22-23, 23-24, and 24-25, that number in recent years has gone from 12 to 15%. Now, the interesting is when you see these numbers, is that now you see that we are actually, there's probation process failures. Because what is happening is you see now the total number. There was 366 disciplinary cases last year, 24-25. But in reality, 55 of those cases were probation violations, which is a separate category because they stem from a prior year, right? And which means the true current year discipline was only 309. And that's significant. That's 15%. We are inflating, by doing it that method, we are inflating the numbers by 15% per year. So that is statistically significant. So in plain language, 15% of what the public is told with this year's disciplinary actions did not even come from this year. So that's pretty significant. The fourth thing is this distortion happens because these categories measure different things. For example, the administrative outcomes that Mr. Vargas pointed to, it measures how many new investigations resulted in discipline in this year. And that reflects the enforcement productivity, investigations efficiency, case aging, accusation. This is the part that I'm excited with because of Ms. Charlene, Ms. Smith, who has now come into this with a new energy, with an open mind, and I respect that. Prior to this, that was not the case. I'm just being honest. So I'm hopeful about that. But here's the second part of it is probation violation outcomes. What it measures how many of the old disciplined doctors violated terms originally imposed in earlier years. So it measures this thing in a really cool way, because what you are now seeing is the probationary process, is the discipline that we're handing out actually working? And obviously it's not, because it's spiked to up to 15% last year, 14% the previous year, and 12% the previous year. You see? So what happens is these probation violations, they point to compliance behavior of doctors. And it also points to, this is the feedback, is the effectiveness of the probation monitoring at the board right now. So we see there's some room for improvement on this issue. And it shows you the at-risk population in the doctor space. They immediately become evident. We were always asking, what is the recidivism rate? This kind of gives you a other angle on that same thing, which is, I thought it was pretty cool when I did the data this time. And this is a historical discipline pattern. And I just want to show you, because it points to the past. So it gives you kind of like, where are we trajecting? And where are we trajecting is we started off at 5%, now we're at 15%. So probation monitoring is an area that we can actually look at. These two represent different functional responsibilities for the board, right? When we mix them, as is in this case, right? And I'm saying this is what we can improve. When we mix them, what it does, it blurs the operational performance, because we're measuring two things that should be measured separately and interpreted separately in order to get the best feedback back into the system. It blurs the risk trends, because when we blur the risk trends, we don't look at the doctors, because we look at this big number and we think, oh, we're doing so good on enforcement, but what it's actually feeding that number is how many doctors are failing probation. That's reality, yeah. That's what the numbers show. It also blurs investigation output. This is kind of like the staff are putting in all this effort in getting these investigations squared away in the current year, and they are not fairly represented. Whether that number is low or high, it gives you a real number of what you can improve upon. That's what I'm talking about. It also blurs the resource allocation, because you think, oh, we need to go spend all this money on enforcement, which we already spend like 70+% of our total budget on enforcement. But what it shows you now is that some of that money needs to be allocated to better the probation process, because that's problematic. There's room for improvement. But what it does do also, it starts masking the declines in accusation-based discipline, because you're mixing it up. So now the accusations look like it's way bigger because we're reading it like that. It further increases the increase that is happening on probation failures. If we go from 5% in 2014-15 to 15% in 24-25, you can clearly see the trend is out of whack. We can do better. And this is with the spirit of doing better. I came in here with the spirit of just giving feedback to do better. And it paints an inaccurate picture for the public and the legislatures. So we start breaching kind of a trust integrity thing, because numbers is easily verifiable. If I can do it, anybody can do this. This is simple stuff. So what the distortion causes publicly, and I've seen this, I listen to it, we hear it on all of this, is that the board looks like it did more disciplinary work this year than it really did. Because we only did so much and the rest was past issues. The legislators and stakeholders are then led to believe that complaint investigations are more productive. And I won't comment on that because the numbers speak to that. It leads them to believe that accusations result in more discipline when in fact it doesn't. And it says enforcement is up because the numbers are up. Numbers are inflated by 15%. It says the risk management, we manage this risk so much stronger, but we're not really. We're hiding risk. And it's inadvertent. This is a little, we can correct this. When in fact the discipline from accusations was actually declining. We do less accusations than we did all these years prior. And it increases, the increases are coming from probation failures. So the probation is failing, yeah, at the bottom, and it bolsters these numbers when we combine it. When we separate it out, they speak clearly as to things that we can do. I'm almost done. But here's the thing that I found most interesting, because I wanted to verify this is not just me, all right? What are the standards that are set by other organizations throughout the country? Because I know that would be a question. So I went to FSMB, the Federal State Medical Board, and their standard is to separate it. I went to the National Practitioner Data Bank, and their standard is to separate it. I went to the GAO, I don't even know what that is, Enforcement Reporting Guideline, and I actually had to chat GPT that because I didn't have any idea what that was. And it had the same guidelines. And then I went to DCA, which I knew had the same guidelines because that's how I started giving those reports on. And so the administrative outcomes and probation violation should never be reported as one method. That's the essence of what I'm saying here today. Doing so is considered statistical misreporting because it doesn't say anything. It just says we're doing better. But that's not what we want to do. We want to have these numbers reflect what we can improve upon. So in conclusion, the direct answer here is, including the probation violations from previous years, distorts yearly numbers. And I'm sure Mr. Vargas will agree with me. This causes the over-reporting of current year discipline, point one, misinterpretation of enforcement productivity, point two, masking of long-term probation failure trends, which we can clearly see, point three, the inflated totals by up to 14 to 15% per year in the last 3 years. That is significant. And the most important thing for me personally is that we must lead the public, the legislator, and other stakeholders understanding. This is where you correct those things because it's fundamental. It's easily verifiable. And the blended metrics that we have now, it just simply violates reporting norms. So that's kind of my presentation, not my presentation, my comment on that numbers. So all I'm asking, genuinely, is that the board, I would like to see those numbers separated. Because if I see those numbers, if I see the probation violations in the probation section, like Ms. Charlene pointed out when she walked through us that, if that is in there and we read those numbers tell a story. Those numbers tell us, do we need more probation officers? Those numbers tell us, do we need stricter discipline towards the guidelines? Those numbers tell us the things that we need to do, corrective steps. So in the spirit of doing everything right, keeping our standard very high, this is the Medical Board of California. We are the standard. And we set the standard because we do the numbers right. Right now, this is not an accurate reflection, but it's correctable. And Mr. Vargas, he's smart enough to fix this. So thank you.
Thank you, Mr. Watkins. If I could just clarify what your specific request is your request that in the executive management reports that come to the board at our quarterly meetings that this information be broken out by probation violation outcomes versus administrative outcomes, because in the annual report, it is clearly broken out. No, could you just answer my question? Like, what do you want to see? You want to see the executive management reports reported in precisely the same way as the annual report is reported?
Yeah,
Is that the request?
absolutely.
Because this information is, I guess I want to make clear, it is broken out clearly in the annual report. And then there's data that gets reported in summary fashion from time to time. And your concern is with the data that's being reported in summary fashion, that it's rolled up.
Let me explain to you why that is important so that this point doesn't get missed. And I'm grateful for the question because it allows me to further clarify. When we do these quarterly reports, right? And those numbers are thrown together like that. You cannot make decisions based on those numbers because they're inflated, right? But if they are broken out, we can have quarterly numbers to see how we are doing as a guideline. And then when it all comes together in the annual report, those numbers have been consistently separated through the system. Nothing is hidden. In the year, when we review it, when we have this board meeting, we can say, hey, but those probation violations are stepping up in Q2. Or what is happening in there? It helps us formulate more clear, actionable questions. Thank you, Madam Chair.
Thank you. Additional comments or questions before I open it up for the public? Are there any public commenters in the room? Dr. Yip?
Thanks for the time and effort to make everyone understand the number more and also to clarify. Just two questions is that on the table, your list license revoke and license surrender. If those are revoked surrender already, why would there be still probation violations?
There are probationers that are on probation that would decided to surrender their license.
At least license revoked, license surrender, that two-line item. If they already revoked surrender, why would still be probation violations?
Can you repeat that again? Sorry.
So when you look at TJ's table, I was asking him to, when he combined the number, there's one item called license revoke, one item said license surrender. Now, to me, they already revoked surrender. Why would there still be probation violations?
But I think the answer to that question is it may not be. It could be totally unrelated. It could be because that doctor decided to retire. It could be.
Exactly. So that would not be violations.
Right.
Well, they have, as part of their probation terms, they have to account for 40 hours of, in practice in California. And sometimes they are not able to, retain an employment or other factors that prevent them, like health-related reasons. And
That's what I'm saying. They are not under probation. They're revoked surrender. Means
right.
There's not be any more probation violations. So just confused by those numbers on this table. So thank you.
Any other comments, questions from board members? Okay, let's go to the public, please. Anyone in the room? All right, seeing none, Sean? You
Yes,
go to
if you'd
WebEx?
like to make it a public comment on agenda item 11, please do so by raising your hand or typing anything in that Q&A window. First up here, we have Michelle Montserrat Ramos. You should be receiving that prompt.
Hi, Sean. Can you hear me?
Yeah, Michelle, please go ahead.
Good morning. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. My concern is that you are presenting my comments are about coding complaints. Some members of this board were present at the August 2023 Bakersfield board meeting when members of the public came before this board and requested a maternal mortality report from board staff. And this board agreed that we would receive this data. It has been almost 2.5 years, and this board has still not delivered this maternal mortality report. Now, I have to let you know that I've met with executive staff regarding this maternal mortality report 2 to 3 times, and I was told that board staff was not coding the complaints to obtain this information for the maternal mortality report. Yet, I read the meeting materials where you are being told that staff is directed to properly code each complaint in a timely manner. So which is it? Are you not coding the complaints for the information we requested as you told me? Or have you been coding the complaints all along as the board materials will lead the public to believe? Or have you instructed staff to go and manually go through the complaints and code them? There are enough doctors on this board to understand what the issue is here. Providers use codes to categorize diseases and causes of injuries. How could you possibly not code these cases without coding the cause of death or the cause of the lifelong injury? At our last meeting, your excuse was that you were working on an annual report, but that has long been published. The bottom line is that board staff knows they should have been coding the cause of death and injury complaints to begin with. If the information on the board materials are accurate, then where is our maternal mortality report? Again, we can expect to receive our maternal mortality report by the next board meeting. Maternal and infant mortality rates continue to increase and continue to be a big concern in our state. We look forward to receiving the maternal mortality report at the next board meeting, which I anticipate will be in Los Angeles. Thank you.
Your public comment. Next here is Rob Gordon. Should be receiving that prompt.
Yeah, hi. Just quick comment on Michelle's comment. Excuse me. I think one of my censored comments was about the maternal report in Central Valley. I remembered myself yelling about that, but I listened to it and I wasn't yelling at the August meeting in San Diego. It's absurd that you haven't given them that yet. Why should you wait till the next meeting even? That should have happened a long time ago, or you should say we don't have it. That it's been 2 years, by the way. It's not even my issue, so I wish you wouldn't count this as my time. I'm sort of like whoever said that you have too many thoughts in your head on this. None of the data makes any sense. You all know what has to happen. At least anybody who's been here for a while. The data should be immediate that day. Now I am organizing an initiative to abolish the Medical Board of California. I don't want it to exist anymore. That sounds unthinkable to a lot of people. That is not. There's a lot we can do. I'm organizing. I'm just starting to organize a little bit on Twitter. I'll be posting today, and I'll also be building a knowledge base. And I absolutely want to invite doctors. Doctors are getting greatly harmed. You're grotesquely violating the rights of both patients and doctors. At the same time, you're not providing the data. You can do all three, or we can do all three. So I totally invite that doctor to join us. There's going to be people in the anti-vax community. I don't agree with their philosophies, but I think we can come together. They haven't done it. I think we can build better systems, do better. And at the same time, I think we can start a political action to abolish the Medical Board of California entirely. So I'm organizing, there's very little there, but abolishmbc.org. If you want to contact me, I'd be happy to set up video conferences with you guys. Also, I know I'm going all over the map here. Also, the forced urine testing, I believe you call it biological fluid testing, absolutely brutal to doctors. I think I'm still analyzing, but I believe you make them answer. They have to like call in every day or something. It's absurd. You could respect their rights better. I also still have my urine challenge out. I will take the urine challenge because that. Now, this was a lot about you guys weaponizing forced urine testing, forced biological fluid testing. If you are told you have to take one of those and you refuse, you're automatically a drug addict in this system. So we got to talk. We've got to make our own systems. We got to get together with liberals and conservatives, all political stripes, doctors and patients. It's too late for you guys. I'm sorry. Your data's a mess. Everything's a mess. I'm building a knowledge base. Of course, we'll have advanced artificial intelligence, multiple models, looked at all of it once it's built. So, feel free to contact me. My name is Rob Gordon. I've been severely damaged. I never got a victim statement. I never was able to tell my story. We can help people. We don't need the medical board.
Thank you for your public comment. Next, here's Marion Hollingsworth. Marion, you should be receiving that prompt.
Okay, can you hear me?
We can, Marion.
Thank you. Hello, this is Marion Hollingsworth, patient safety advocate. I'd like to thank Mr. Watkins for bringing out the inaccuracies of the medical board disciplinary statistics. I've often wondered how honest the board has been with its numbers because there's no way the public can know whether this information is true or not. We just have to go on blind faith, so to speak. Taking into account Mr. Watkins' findings that there were only 309 true disciplines, this drops the board's disciplinary rate for the last fiscal year from an already dismal 3.7% to a mere 3.1%. Whenever I speak to reporters about a doctor's case, I always mention the board's poor disciplinary rate, and it makes you all look bad, like you don't care as much about the public as you do doctors, and people need to know this when they're filing a complaint. Please take Mr. Watkins' suggestions seriously and make corrections to your statistics so the public has accurate disciplinary numbers and we know how you are doing to protect us. Thank you so much.
Thank you for your public comment. Next, here we have Tracy. Let me get you that request.
Good afternoon. I am Tracy Dominguez, and I am from Bakersfield, California. I am a volunteer with Consumer Watchdog. As long as we are talking about board enforcement data, we're really talking about what the public needs. I was present at the medical board meeting in my hometown, Bakersfield, which was held in August of 2023. We were incredibly pleased with the board did bring the meeting to Bakersfield. Thank you. The state senator in the State Rules Committee also shared with you how important your outreach was to hosting a meeting in Bakersfield. At the Bakersfield board meeting, I was one of many mothers who requested the board present us with a maternal mortality report, and the board staff and you agreed that we would receive it with this data. It was almost 2.5 years ago. This board is still not delivered this maternal mortality report. Now that I have seen that you have coded enforcement data and have coded each case in a timely manner, this leads me to think again, where is the maternal mortality report? We did not have 2.5 years to wait for this report with no actual response or when we would receive it. We have heard that it should have been placed on some future agenda, but that is not good enough. Well, the report runs out of excuses. Well, this board runs out of excuses with young mothers and babies keep dying and experiencing lifetime long harm. The maternal mortality and infant mortality crisis is only increasing. We are trying to do our best to work with you, but now you need to deliver on your promise. We will expect the maternal mortality report to be offered and present at the next board meeting in the beginning of the year in August, in the beginning of the year in Los Angeles. My daughter was failed and my grandson was failed by this board. And you are continually failing her. Please do your job and protect patients and do what you say. Thank you.
Thank you for your public comment. This time, there are no additional requests in queue.
Thank you, Sean. I will go ahead and bring it back to the board. Well, excuse me, first public comment in the room. All right, seeing none, I'll bring it back to the board. Dr. Tsai, did you have a comment?
Yeah, I have a question. Obviously, I agree with comparing apples to apples. I wanted to ask our executive director, is it possible to provide the annual type of data that Mr. Watkins is asking for on our quarterly summary, or is it a statistical computing issue that we can't compare apples to apples until at the end of the year?
That's definitely something I took note of to see if we can make sure those data sync. Because like Ms. Lawson pointed out that it is separated in the annual report. So yeah, we'll go back and work on it. And as I presented in my report, we are presenting what is being presented to the board based on what the previous leadership and the previous execs and, you know, over time, how it was presented to the board. And so, yeah, we'll definitely go back and take a look at that. Thank you. Thank you for the feedback.
Additional comments or questions? All right, seeing none, we're going to move on to agenda item 12, which is discussion and possible action related to the Midwifery Advisory Council, the MAC. Do we have Ms. Weisner with us?
Yes, Ms. Weisner, I've promoted you to panelist. You should be able to activate your video and unmute.
Hi, good morning, everyone. Can you hear me and see me?
We can.
Awesome. Well, I'm Madeline, and I'm a California licensed midwife, and I'm the chair of the Midwifery Advisory Council, or the MAC. I'm pleased to provide you with an update on the MAC, and we'll be requesting a motion to approve the 2026 MAC meeting dates. And I also seek your approval of the agenda items for the next MAC meeting. The last MAC meeting was held on September 11th, 2025. At this meeting, the following actions were taken, or the MAC was provided the following information. We approved meeting minutes from the April 3rd meeting. We received an update from the MAC chair, as well as an update on midwifery legislation, and from the Task Force on Medi-Cal related issues with midwifery. We received an update on the midwifery program and licensed midwife annual report. The MAC voted on and approved the following 2026 MAC meeting dates, which are January 22nd, April 16th, and September 17th of 2026. We received a presentation on the frequency and rationale of free birth or unassisted birth. We had a discussion on environmental exposures faced by midwives. We had a discussion on the midwifery payment model through Midwifery Access California. We had a discussion on the accessibility and sustainability of California midwives, and also discussed providing a presentation to the medical board regarding midwifery history and updates. And we also had a discussion on the Community Birth Partnership Initiative. So very productive times. The MAC is requesting your approval of the meeting dates of January 22nd, April 16th, and September 17th. The following are our proposed agenda items for the next MAC meeting, which will be held on the 22nd of January 2026. Those agenda items are the approval of the minutes from the September 11th meeting, report from the MAC chair, report from the Task Force on Medi-Cal related issues, an update on midwifery related legislation if applicable, an update on the midwifery program, discussion and possible action on providing a presentation to the board regarding midwifery history and updates, and a presentation and discussion of the licensed midwife fund condition. May I please have a motion to approve our selected meeting dates, as well as the agenda items I listed for the next MAC meeting?
Thank you, Ms. Weisner. Are any comments or questions for board members?
I move to approve the Midwifery Council meeting dates and agenda items.
Thank you, Dr. Sai. Do I have a second?
A second.
Thank you, Dr. Mahmood. Are there any comments from the public present in the hearing room? Sean, are there any public comments on WebEx?
So if anyone would like to make a public comment here on agenda item 12, please do so by raising your hand. Type anything into that Q&A window. First up here is Rob Gordon.
Yeah, hi, real quickly, I've been doing some research to find out how this abomination called the Medical Board of California happened and how it's done so much damage. And so I've been reading up on the history.
Mr. Gordon,
No,
do you
this
have
is
a
a
comment
topic.
on the midwifery advisory?
This is on topic. Are you going to censor me again? That was the dumbest.
I just
thing.
want to make sure you're on topic.
I am totally 100% on topic. To find out how this happened, I have been researching this, and I know the Medical Board of California 100 and some years ago, the allopaths they were called then, viciously attacked the midwives. So all I was going to ask is if we can get the report. I would like to learn more about the whole history of the medical board to find out how the damage happened in my life. All I was going to ask is, can we get the report she mentioned? You're going to give it to the board of directors. I want to know if it will be available to the public. Gosh, I'm sorry, your first instincts are to censor everything. It's rather absurd. 3 minutes was not too much to ask. Anyway, I won't again. We'll take the conversation elsewhere. Thank you. That was a nice presentation about the Midwife Council. I'm sorry I've spaced out in your name. Go ahead. I'm done.
Thank you for your public comment. This time I don't see any additional requests in queue.
Thanks, Sean. Dr. Yip?
Thank you. I'm just going back to the annual report about the midwifery, and our enforcement staff also looking at those data like license renewal, accusation, or totally under the purview of the Midwife Council. Like, for example, the report on the midwifery, like accusation 239 and a man accused, etc. The statistic there, I'm just curious, are those also under your supervision or totally under the midwife director or the board?
I think the question is, are the enforcement actions related to Midwifery Advisory Council rolled up into our data, or are they reported separately? Is that the question?
Also, are they under the supervision or the review by the executive director and also the enforcement chief, or the?
Mr. Varghese, can you answer that? Yeah.
Great, thank you.
Yes.
The MAC does not make disciplinary decisions about the midwives.
Right.
So it's this board and the executive director.
Good.
Excellent. Thank you. Any additional comments or questions? All right, Ms. Struther, if you could perform the roll call vote. We did have a motion from Dr. Tsai and a second from Dr. Mahmood to approve the request from the MAC.
Dr. Ayala Rodriguez,
Yes.
Mr. Arkatov,
Yes.
Ms. Chung, Dr. Mahmood,
Yes.
Ms. Torres,
Yes.
sorry, Ms. Remke,
Yes.
Dr. Solis,
Yes.
Dr. Thorpe, Dr. Tolbert,
Yes.
Dr. Tsai,
Yes.
Mr. Watkins, Dr. Yip,
Yes.
Ms. Lawson.
Yes, that motion carries. All right, moving on to agenda item 13, future agenda items. Do any members have suggestions for future agenda items? I see Dr. Mahmood, then Dr. Yip, then Dr. Thorpe.
Yes, I want to bring back on board the essential vaccinations and federal government actions against stopping some vaccinations, and what should California move in which direction. Bring some expert and get into the detail of that, because there's a recent order, hepatitis B virus being banned now for newborns, and I think it's a huge health risk, and it's prime responsibility of Medical Board of California to address these issues, because more and more vaccination process or ban is going to come up. So I think this should be taken as a priority.
Thank you. I concur with that suggestion. Dr. Yip?
Thank you. Couple of things in response to the public. I think hopefully we can find speaker on the topic of long COVID. Second is hopefully we can provide some data on the maternal mortality in this board meeting. And the third is that I do feel it's possible if we can have a draft of the minute in a month rather than like a few weeks before the meeting. Number one, it refresh our memory. All the board members excited to do things, but then after 3 months, they may not have the memory of what needs to be done, and that's I think is helpful. The second is that I do have concern about online comment that number one is hard to hear. If possible, we can look at some AI software that they can actually have transcription, and we can have a disclaimer that is not like approved or edited by the people calling for comment. At least we can read it. At least we can follow up on it and be more productive. Thank you.
Thank you. Dr. Thorpe?
Dr. Yip stole my thunder, but which is fine. I do want to just make a I think the board knows, but on the 17th of this month, 2 weeks, the board has, with a great deal of effort from our executive director, in collaboration with the Board of Pharmacy, the Nursing Board, the PA Board, the Attorney General's Office, the DCA, has put together a symposium on the difficulties and the problems associated with opioid prescribing. And really, that has come out of a lot of public comment about concerns for lack of access. It's a very first start, a collaborative sort of approach. But I just wanted to say thank you to the executive director, and just to let you all know, it is, I don't know if there's still available slots or not, but it's full. Well, sorry, if you haven't signed up, it's too late. Thank you.
Dr. Thorpe, Mr. Watkins.
I just want the future agenda item to discuss the notice to the public on doctors being investigated.
Right, thank you. Dr. Ayala Rodriguez.
Thank you. I think that in the future, I echo the maternal mortality report. I think that when I watched the recording from the Bakersfield meeting, there were several stakeholders, and I think that in awareness of how long things take, I think that that's something that has to be planned out, because to generate a report, even internally, that's something that I imagine is going to take months. If we need any other stakeholders, I imagine that's going to be something that is going to take months, a lot of collaboration and things like that. But I think that that's something that it's necessary in California, to pay attention to, but it's going to take time. So I think that it's important to consider that and to kind of have a tentative timeline for that, because I think that if we really want the right stakeholders, the meaningful stakeholders, like public health department and other stakeholders, I think that requires time. So the sooner that gets called out, the better. To have a reasonable timeline, because I imagine that that's going to take some time. But other than that, to me, I think that the AI conversation, I think that it's important. I think at least I was appointed about 1.5 years ago, and that was something that we were mentioning back then and continue to be mentioned. That's a field that continues to evolve very rapidly. And I think that it's going to be impossible to have guidelines for everything, but we should be able to strategize on how to have best practices for safe adoption, because even having no action, it's an action. And we know that there's more implementation, there's more people utilizing different AI tools for different things. And there's very basic concepts that we could be following, or at least recommending onto how to safely incorporate AI into practice and things like that. Thank you.
Thank you. Additional future agenda items, Ms. Remke?
Similar to the enforcement presentation today, which I thought was very helpful and informative, I'd be curious about the possibility of having a presentation by someone from the Attorney General's office on their role and involvement. I know that the executive director and the chief of enforcement have a close connection with them, but I feel somewhat removed from it, and I think it would be a certain level of comfort to know more how they're handling it, especially when we look at how much time is spent there for a case.
Thank you. Additional comments or suggestions for future agenda items from board members? All right, seeing none, I'll open it up for the public. Any comments from public in the room? All right, Sean, let's open it up on WebEx.
If you'd like to make a public comment for agenda item 13, future agenda items, please do so by raising your hand or just typing anything into that Q&A window. First up here, we have Monty Goddard. Monty should be receiving that prompt.
Good morning. My name is Monty Goddard. Most of you do not know me. That is precisely why I'm commenting on future agenda items. Let me explain. I'm a licensed California civil engineer and an advocate for my wife, who has been an intractable pain patient for 2.5 decades. I'm a member of the Speakers Bureau, the national campaign to protect people in pain. My colleague and I are slated to present at the Sacramento December 14th forum Dr. Thorpe just mentioned. I too am grateful to Executive Director Varghese on making this forum happen. I participated as an interested party in the board's 2023 opioid prescribing guidelines update. 2 board meetings stand out in my memory. of that encouraging process. First is the board's February 2022 meeting at which Stanford University's Dr. Sean Mackey made an outstanding medical board requested presentation on pain management. It was obvious several board members had an eye-opening experience. I believe Dr. Mackey's presentation, in addition to Dr. Thorpe's exceptional stewardship, was foundational in the board's unanimous approval of your updated guidelines at the board's May 2023 meeting. Both of these meetings were very encouraging to the pain patient community. However, fast forwarding to today and comparing board membership in February 2022 and May 2023 with board membership today, I'm concerned. Only 4 current board members, President Lawson, Dr. Mahmood, Mr. Watkins, and the amazing Dr. Thorpe, were on the board throughout the process, which produced your July 2023 guidelines. Recognizing Dr. Sai has joined the board by May of 2023, only 5 current board members were on the board when the guidelines were unanimously approved. I therefore request a future agenda item similar to Dr. Mackey's February 2022 presentation to ensure that all new board members receive the same type of education which benefited prior board members about the proper treatment of chronic pain. If such an agenda item cannot be scheduled in the near future, as a minimum, I request all new board members be required to view in their entirety the videos of agenda item number 3 of your February 2022 and agenda item number 10 of your May 2023 meetings. Thank you for your consideration.
Thank you for your public comment. Next, here's Marcus Friedman. You should be receiving that prompt.
Hello, Marcus Friedman, Administrative Director for the Consumer Protection Policy Center at University of San Diego School of Law. CPPC is in support of Board Member Watkins' suggestion to increase transparency when a doctor is investigated for professional conduct, especially as staff prepare for the next sunset report. Thank you.
Thank you for your public comment. Next here we have Rob Gordon. Rob, you should be receiving that prompt.
Yeah, hi. Thank you, Sean. Again, I've been looking at the history of this, and I'm not very far into that yet. But this pearls before swine approach you used to public communication, I believe, started about 10 years ago. I believe Dr. Thorpe said, let's arrange a meeting or something. What I got to say might surprise you a little bit, but for our next agenda item, I think I would like to hear each of you pretend you're individuals for just one meeting or one brief session, and I would like to hear your vision, what you want to get out of your role as an MBC board member, what you think should happen, why you're here. I think some of you might be here for prestige, some of you might be here to advance your political careers, some of you might be here because you think it's public service. I want to, or enforcing standards. I want to know what that is for each of you. And I want to know your vision, because I've been participating in this part for 2 years, and I started trying to get through the complaints after July 2020. You had front seat to what happened to me, and you actually participated in my prosecution. But I want to hear you. I want to hear you guys give me your vision. Was a project manager most of my life, and sometimes I know you have to slow down to speed up. So that's what I would like to do. I want to hear your vision, what you want to do, and that's really all I can think of. I'm going to be organizing my knowledge base. I'm just starting, but it will be at abolishmbc.org. Anybody wants to contact me, again, doctors, patients, whoever. So anyway, have a nice holiday. I will be working on your craft this over the holiday. Thank you.
Thank you for your public comment. I saw some hands going up and down, so if anyone would like to make a public comment, please ensure your hand is up. Last in queue right now is Michelle Montserrat Ramos. Should be receiving that prompt.
I'm Michelle Montserrat Ramos, and I'm with Consumer Watchdog. An enforcement public meeting without a 3-minute comment limit for the public, but a back and forth dialogue with the board and staff. Thank you to Dr. Yip and Dr. Ayala Rodriguez. I agree. Maternal mortality report release for the next board meeting, not sometime in the future. And we also support TJ Watkins' proposal in reporting enforcement data. Thank you.
Thank you for your public comment. At this time, there are no additional requests in queue.
Thanks, Sean, and thanks to all the public commenters. We will bring it back to the board. Any further comments? Okay, seeing none, the board is going to be moving on to agenda item 14, which is a closed session to conduct the annual evaluation of the executive director. I do want to note that we will be returning to open session for adjournment, but due to technical limitations, we will not be broadcasting the adjournment. So we are now going to head into closed session. Thanks, everyone.
If I could ask Ms. Lawson for like 5 minutes to switch it over. Break.
Okay. Check out clear.